SJC-12398, Julio Acevedo v. FHA Musterfield Manager, LLC, and another.
Mr. Egan, good morning.
Thank you. Good morning. May it please the court. John Egan for the Musterfield defendants. With me is Laura Kelly, who was also on the brief. A public housing authority's controlled affiliate is created with the approval of the Department of Housing and Community Development for the sole and very specific purpose of allowing a public housing authority to use federal low-income housing tax credits as a funding source for the renovation of low-income public housing. That is its sole and exclusive function, and that is its sole and exclusive ability under the law.
Just a clarifying question. Who's behind Musterfield Place LLC? Like, who owns that?
It is owned by three member LLCs. One is FHA Musterfield Manager, which is itself an LLC, and the only member of that LLC is the Framingham Housing Authority.
Right.
The majority member, the owner that owns 99.99% of the equity in that LLC, is the investor member, which is where the money comes from.
When you say that LLC, you're referring to the FHA manager, or are you referring to the first LLC?
No, I think I'm referring to the Musterfield Place LLC, which is the controlled affiliate in this case. So for ownership purposes, 99.99% of the Musterfield Place LLC is owned by its investor manager. The investor manager is the low-income housing tax credit syndicator, and that's the source of the money for the rehabilitation project that is the subject of this. And in exchange for those funds, the LLC is entitled to receive low-income housing tax credits from DHCD and then allocate them in turn to the investors. The two most important conditions that attach to the creation of a controlled affiliate and DHCD's approval of the transfer of property to that controlled affiliate are, number one, that the actual and legal control over the operation of the public housing development shall remain exclusively in the hands of the Public Housing Authority for all purposes. There are no exceptions.
Can I ask that? So the Framingham Housing Authority LLC, the people who do the actual work, who pays their salaries?
Framingham Housing Authority.
So when the person who's the Framingham Housing Authority LLC does not pay anyone's salary.
Well, there's actually no Framingham Housing Authority LLC.
Okay, then I'm confused.
There is an FHA Musterfield Manager LLC, which is designated in the papers as the managing member of Musterfield Place LLC. The only member of FHA Musterfield Manager LLC is the Framingham Housing Authority in its conventional corporate format.
So the people who go around and maintain this building, they're all paid for by the house. All their salaries are 100% paid for by the housing authority?
That is correct.
So you get basically free management.
Yes, I mean, there is the intent of these regulations, the intent of the approval letter, the intent of the operating agreement, I think is clear that there should be absolutely no daylight, no distinction between the operation of this tax credit property, which is sort of the colloquial terminology that's used in the field, the operation of a tax credit property and the operation of a more conventionally owned and operated public housing authority.
So let's assume all that to be true. How do you get around the 258, Section 1 definition of public employer, which expressly says it is not any other independent body, politic, and corporate?
Because this is not an independent body, politic, or corporate. The controlled affiliate
So
is...
you think independence means something more than separate and distinct? You think we need to sort of go into whether or not you are truly independent of them, or simply that you are separate from them?
Actually, what we're not asking for the court to specifically define a controlled affiliate as a public employer. What we're asking the court to do is to look at the entire regulatory framework under which these controlled affiliates are created, and to make a decision and issue a ruling to the effect that for purposes of tort liability, the controlled affiliate should be subject to the same rules as a public housing authority is. It is in every respect intended to be completely indistinguishable from a public housing authority.
But isn't that an argument that you need to make to the legislature to revise Section 1 to include a controlled affiliate? Because you're saying you may not be a public employer, and the Tort Claims Act applies only to public employers, but we should treat you as if we should basically amend Section 1 and say there is this other category which it makes really good sense to include.
Well, Section 1 was written before the Tax Reform Act that created the Low-Income Housing Tax Credit Program, so the one preceded the other. It is not unusual for statutes and regulations not to have closed every loop and dotted every I and crossed every T and covered every conceivable set of circumstances.
Are you an owner?
I'm sorry?
Are you an owner?
The owner of the property, at least on paper, in 2013, when this accident occurred, was the Musterfield Place LLC. Our position is that the owner of the property, Musterfield Place LLC, as a controlled affiliate, is not a conventional owner of real estate.
So don't we default to the common law? If you're not covered by the Tort Claims Act, do we not just default to the common law rule and say that every owner is responsible?
Well, yes, and that's my brother's position, is that it's a simple matter of they're either a public employer or they're not. If they're not, then the common law applies. Our position is that this controlled affiliate has absolutely no authority to manage or control this property. In fact, it's barred by the regulations, by the DHCD approval letter, by the terms of the operating agreement, which was itself part of DHCD's approval of this transaction. The controlled affiliate is barred from having anything to do with the operations and management of this property.
Do you have a duty to inspect?
The housing authority does.
You don't?
The housing authority, in a conventionally owned housing authority, housing development, has duties to inspect, duties to maintain and operate, repair as needed, and those duties continue to prevail even in this case. The question is whether that duty devolves on Musterfield Place LLC, and if it does, is that duty unrestrained and unrestricted by Chapter 258? And our position is that where all of the regulations that permit the formation of this controlled affiliate and permit the transfer of the property to that controlled affiliate for the specific, narrow, sole, and exclusive purpose of being able to generate funding through the low-income housing tax
So
credit program.
you're simply a pass-through for tax credits. You have no liability.
Correct. They're simply a pass-through. The liability remains with the managing agent, the Framingham Housing Authority, as it would if this controlled affiliate didn't exist. Keep in mind, Your Honor, that the controlled affiliate brings nothing to the table. It is not a financial partner with the Framingham Housing Authority. It brings no managerial expertise. It is a completely passive, virtually inert owner. It is a paper corporation that's established solely for the purpose of acting as a pass-through for the infusion of capital improvement funds to renovate this property in exchange for housing authority, low-income housing tax credits. It cannot do anything. It is barred by the regulations from doing anything. It can only act through its managing agent, which is required under the regulations, under the DHCD approval, and under the operating agreement to be the Framingham Housing Authority. So there is nothing about the operation and management of this particular property, even as owned by Musterfield Place LLC, that is the least bit different from a conventionally owned public housing authority.
And the rent itself, none of that goes to the equity owner, the 99%? It all goes to the Framingham Housing Authority?
It does. The presence of the controlled affiliate has absolutely no financial impact on the operation of the housing authority.
The only revenues they get are the tax credits, essentially.
The only revenue that the controlled affiliate investment member gets are the tax credits, which are of value to a high net worth institution with substantial tax liability. And the only money that the investor manager puts into this is the initial infusion of renovation capital in a dollar-specific amount for a very specific cause. And that money is stretched out over the tax credits are stretched out over a 10-year period of time. The controlled affiliate does not become an extra source of financial wherewithal to the public housing authority. It has no impact on their annual operating budget, and they have no impact on the management function of the housing authority, which remains at all times with the public housing authority.
But isn't your better argument, 258, Section 1 limits the Tort Claims Act to public employers. You're not a public employer. Isn't your best argument to say we should revise our common law imposition of duties upon an owner because you're sort of only an owner, but you should not have the same common law obligations of an owner, and that is something that courts can do, whereby courts cannot amend statutes where it does not include you?
If the court chose to analyze it in that way, I certainly wouldn't. Certainly wouldn't be disappointed. If the better way to analyze this is to reform the common law so that an entity that's designated as a controlled affiliate under this set of regulations shall not be liable in excess of whatever Chapter 258 dictates, then I suppose that's one way to get to the same result.
But that's not the issue before us. The issue before us is purely Tort Claims Act.
It is.
We wouldn't be deciding that, but it seems as if you're asking us, we can do common law remedies, but we can't amend statutes. That's the fundamental problem I see here.
I don't think it requires an amendment of the statute. The statute, I don't have the language in front of me here, but I think the statute describes a variety of corporate entities, boards, divisions, agencies, authorities, and so forth, that I think can be read broadly enough to include a regulatory-created affiliate of an authority that is understood already to be a public employer. There's no question about that.
What language would you be seizing on when the statute, I know, says, or that your public employer is not, quote, any other independent body politic and corporate?
Well, we know that a public housing authority is a public employer. That's been well established. Yes. And the fact that the statute lists a number of other possibilities, Commonwealth, city, town, boards, divisions, agencies, authorities, I think is a broad enough collection of other possible entities that it could include a controlled affiliate of a public housing authority that is itself a creature of regulations. It's also, these regulations also flow from Chapter 121B, the Housing Authority Enabling Statute. The Housing Authority Enabling Statute very specifically says that a public housing authority shall have the authority to create instrumentalities or agencies, I think is the language of Section 26M, for the specific purpose of generating funding from federal sources. So the creation of a controlled affiliate is expressly contemplated by the Housing Authority Enabling Statute, Chapter 121B.
I have a note, and maybe you can help me out, that the Mass Code of Regulations defines a controlled affiliate as an entity with the power to own and manage residential real property, over which it has actual legal control, and shall be a licensed housing authority.
Well, it's the second part of that, I think, that's the most critical, that the actual and legal control over a controlled affiliate must at all times remain in the hands of the
Right,
public
but
housing
you
authority.
have the power to own, which you do.
They do.
But you also have the power to manage.
Well, in the first instance, yes, they have a power to manage, but the second half of that very same sentence says that all such power to manage and operate must reside in the hands of the public housing authority. So,
I'm confused. Isn't there a third entity, though? You've got the controlled, you keep referring to the controlled affiliate, which is Musterfield Place LLC, right?
Correct.
There's also FHA Musterfield Manager LLC.
Correct.
Is that different? And what do they do?
FHA Musterfield Manager is itself an LLC.
Right.
It is one of three members of Musterfield Place LLC.
Right.
And the only member of FHA Musterfield Manager LLC is the Framingham Housing Authority.
Right, but that's, I'm wondering whether, but does that FHA Musterfield Manager actually, LLC, manage the property? I mean, I understand that its only member is the Housing Authority, but have we blended the Housing Authority into a private entity in a management capacity there?
Well, it's kind of a public-private hybrid.
Well, but doesn't that start getting dicier then? Then there isn't this, everything is done by the FHA, and your controlled affiliate is not involved in anything, but there's a third entity that blends the two, right?
But everything that FHA Musterfield Manager does is done through the Framingham Housing Authority.
I understand.
There's
but
no independent.
There's some reason why it's created, right?
It's done for some, it's done for some obscure corporate reason that has to do with the formation of LLCs under Massachusetts law.
Can I ask
But
them
it has no impact on the actual operation of the public housing
Does it
authority.
pay anything, and does it receive any revenues?
It receives no revenues, it has no employees, it has no budget.
And it doesn't pay, it doesn't have any payment function to the FHA people when they're doing work there?
It does not.
So what does it do? What does FHA Musterfield Manager LLC actually do?
Strictly speaking,
Honestly,
it does nothing.
It's just part of this tax gimmick?
It's, if you'd like to call it a gimmick.
Yeah.
If it is part of the overall ownership and management structure of the creation of this controlled affiliate.
We've learned a lot from you this week, Mr. Egan. This is,
It's low-income housing tax credit week.
yeah.
Our position essentially is this, that it creates an almost infinite number of both conceptual and operational problems if the controlled affiliate of a public housing authority, which itself has no authority to do anything, has no employees, no budget, adds no financial resources to the operations of a public housing authority, and is simply a completely passive and inert paper pass-through in order to generate revenue for a much-needed rehabilitation project in exchange for federal low-income housing tax credits. If that entity, that paper entity, is not afforded the same treatment under Chapter 258 that the public housing authority itself is, and this goes beyond just the damages cap, which is the easiest attribute of Chapter 258 to latch onto. It has a lot to do with how we administer and litigate a tort claim against a public housing authority that is combined with a tort claim against this paper corporation that holds title to the property, in circumstances where Chapter 258 is deemed not to apply to the latter. And we've tried to outline some of those
Your brother
difficulties.
mentions, I'm not sure if it's in the record, a mortgage agreement in which you promise to have liability insurance, that you commit to maintaining liability insurance. Is that correct?
It is, and public housing authorities, including Framingham, have had liability insurance forever. And there's case law we've cited in our brief to the effect that that has no effect on the applicability of Chapter 258 or the applicability specifically of the damages cap. So,
It does go to your parade of horribles, does it not?
I'm sorry?
It does go to your parade of horribles in the sense that pragmatically you'd have to get liability insurance, but you already have liability insurance.
They already have liability insurance, and in terms of the parade of horribles, we've outlined one in our brief. If in fact the owner of this property is deemed not to be a public employer, and if by chance there is no insurance coverage, or if there's a coverage problem, and a damages lawsuit results in a catastrophic loss that's not easily payable by the housing authority or the housing authority's liability insurance, the owner, as a non-Chapter 258 non-public employer, that property is now subject to being levied on execution. That's not permitted under Chapter 258. So in terms of where the horribles lead us, there is the possibility that public housing might be lost in response to a damages award in excess of the limitations of Chapter 258. And I think reading through the regulations and the terms under which these controlled affiliates are created and property is transferred to it, it is hard to imagine either the legislature or DHCD thinking that that was one of the ramifications of creating a Section 4.15 controlled affiliate.
All right, thank you.
Thank you.
Mr. Tennyson.
May it please the court, Chester Tennyson appearing for Julio Acevedo. The role of Musterfield Place LLC is just a little bit beyond what counsel just argued. Not only did they acquire all right, title, and interest in this property through a quitclaim deed, but there was a operating agreement between Musterfield Place LLC and the FHA, the Framingham Housing Authority. And what it specified is that Musterfield Place LLC was the owner and had the obligation to redevelop, own, and operate the property. That's at the record appendix of page 159. Now, Musterfield Place was formed just like every other business entity. A registration was filed with the Secretary of State. And Musterfield Place LLC is actually owned 99.9% by private investors.
But it really isn't. I mean, to equate this to a normal private ownership it really isn't, right? It's clearly all a creation of the low-income housing tax credit law. It's not a normal ownership in any, right?
I submit that it is, and here's why.
Really, they don't control anything, do they?
Well, There is actually, in order to avail themselves of the low-income housing tax credit, they have to bear the benefits and burdens of property ownership. Here, they would like to have the benefit, but don't want to have the burdens. That's actually cited on page 24 of Musterfield's brief. They have to have the benefits and burdens. And some of the burdens that they agreed to undertake here were to maintain the property, repair the property, inspect the property, and insure the property. All property owners have the obligation or the burden of tort liability on top of that. So Musterfield Place LLC is clearly not a public employer. They don't even meet the public employers under Chapter 258. There are two reasons for Chapter 258. One is
Now, your brother argues that they actually don't have any ability to, they have no employees. The entire operation is run by the FHA. Is that incorrect?
as far as I know, Musterfield Place LLC does not have employees. They rely upon the Framingham Housing Authority to do the actual work. That's part of the agreement.
And they don't pay them anything to do that work either, right?
No, that's part of the agreement for the finance.
Like basically, they get tax credits, but they don't pay anything or receive any money, right? And they
Well,
don't
they
have
put
any,
6
they don't have any ability, do they actually have an ability to manage the property?
Well, according to the operating agreement, they do. They have
And what provision in the operating, could you read the relevant part to us?
Well, what it says, it refers to Musterfield Place LLC as the owner, and it says Musterfield Place LLC will redevelop, own, and operate the project. That's at page 159 of the record appendix. And at page 234 of the record appendix, they had the obligation to maintain the property, repair the property, inspect the property, and insure the property. And in fact, they did. They went out and bought liability insurance. One of the purposes of Chapter 258 is to protect public funds. There are no public funds at risk here.
Well,
They're
I mean, they're putting in all the money to subsidize the housing, right? This is not a private landlord, right? I mean, I understand you may be right, but it's all a creation of the low-income tax credit statute. They're not, all they're making money on is the tax credits. They're not doing anything else, it seems like.
The Low-Income Housing Tax Credit Act did not create this LLC. This LLC is a private LLC, just like any other.
Created in response to the low-income housing tax credit. Its only purpose is to get money into low-income. It's to develop low-income housing and provide support for it. It's not a profit-making entity. I mean, it gives them tax credits.
Right, and the tax credits are valuable to the private investors who own 99.9% of this LLC that was not created by statute, not created by any regulation, and owned all right, title, and interest in the property, had the obligation to own and operate, maintain, insure, inspect, repair. It's just not a public employer under Chapter 258. And if a change is going to be made, I suggest that it would have to be an amendment of Chapter 258. If there are no other questions, I will rest on my brief.
Okay, thank you.
Thank you.